Good evening. This is Justin Meyer from Rosenthal Meyer. I am excited to be with you for this year's first of two, or at least two, amendment presentations. And let's jump into it. This is being recorded, so if there are people who want to come back to check on it later, we should have this online a little later on this week. I do have the chat open, so if there are questions, feel free to drop messages into the chat. And yeah, we'll be doing this again, probably around the end of October. So if you really liked it and you want to watch it again, you should feel free to. If you want to tell your friends, we're doing this early because mail-in ballots are going out probably later this week. So we wanted to get ahead of the mail-in ballots getting mailed out, and then we'll do it again a lot closer to when the actual election is taking place. So what we're going to be doing today, we're going to be going over the amendments for both the Florida Constitution and the Orange County Charter. There's about 6 amendments and 10. So we're going to get into it. It gets a little into the weeds. A little bit about me before we get started. I'm an attorney licensed in Florida, along with New York and New Jersey. I'm licensed in 3 federal courts as well. I'm active in the East Orlando Chamber of Commerce, and part of my activity there is as co-chair of the Advocacy Committee, where we really get into chamber advocacy and advocate for positions, but not people. I'm an attorney with Rosenthal Meyer. We help clients with estate planning, probate, Medicaid planning, business law, and real estate. We also do title insurance, so we can help people who are buying and selling real estate in a couple of different ways. Jumping right into the Florida constitutional amendments, there's 6 on the ballot. 2 of them come from citizen referenda. 4 of them come from the legislature. In order for an amendment to get past the Florida ballot, and be put onto the Florida Constitution, needs 60% of the vote. That means a simple majority is not enough. You need 60% of the people to say yes. Not 60% plus 1 vote. It's 60% gets you there. So of the 6, the first 2 and the last 2 were the ones that were put on by the legislature. And the first one is one that I think a lot of people are sleeping on. I'm gonna be honest. I think this is one of the more important ones, and people are not paying as much attention to it. I won't tell you how to vote, but I am gonna flag some of the important ones for you. This is about partisan election of members of school boards. So district school boards are nonpartisan elections. What that means is you don't, in theory, you don't know what somebody's party is when they're running for district school board. Yes, in Orange County, that information has been made public, and there's been mailers about it. I'm sure I'm sure it's been done in other counties as well. Because it's nonpartisan, everybody gets to run in one primary. So if there's 4 or 5 candidates, they're all running against each other in one primary. And unless somebody gets 51% of the vote, the top 2 candidates go on to the November election. It does not matter who is a Democrat, who is a Republican. It doesn't matter, and none of that matters because it's a nonpartisan election. What that also means is it doesn't matter if you are a non-party affiliated candidate. Everybody runs in the same primary. In some cases, if that means that there's a non-party affiliated candidate, an NPA candidate, they would have to win in the primary in August. What does a yes vote do? A yes vote would make that the primaries in August partisan, which means that the Democrats would have a primary. The Republicans, if they're running any candidate, would have their primary. So if one party's not running a candidate, you'd have a universal primary. If there are non-party affiliated candidates, they could end up on the November ballot without having to go through the top 2 primary system. And that's a yes vote. So a yes vote would essentially create a partisan primary, and then the Democrat would run against the Republican. If only Democrats or only Republicans file for the election, it would be decided in August, and whoever won that would go straight on, almost definitely to win. Again, there could be NPA candidates as well. A no vote keeps the current system in place. What that means is that the top two candidates might both be Democrats, might both be Republicans, might be something we don't really know. So that's what the no vote would do. A no vote here would keep the current system in place. The legislature cannot change this one. Amendment 2, the right to fish and hunt. So right now, Florida allows a lot of fishing and hunting. It's the way it is. Florida allows for a lot of fishing, a lot of hunting. Everything in fishing and hunting is enforced by the Florida Fish and Wildlife Conservation Commission. That's the game wardens. That's the people who you see the videos sometimes on TikTok. They're coming out, they're checking on the boat. There are no laws that people are looking to put in place that would severely limit the ability of people to fish and hunt, but in theory, you could. So a yes vote provides for a constitutional right to hunt and fish, acknowledges that that is the primary way that the state of Florida has chosen to manage wildlife and wild animals. It does also protect traditional methods of hunting and fishing, bow hunting, for example. However, it does not prevent regulation. It doesn't prevent the state from issuing game permits, hunting permits, fishing licenses. Doesn't limit any of that. It gives a right to do it, but does not limit the ability of the state to regulate it. A no vote keeps the current regulations in place. It does allow, again, for the legislature to put additional regulations in. In this case, a yes vote doesn't prevent the legislature from putting additional restrictions in as well a lot of the time. Amendment 3. This is the first of two citizen referendums. And this is the marijuana amendment. What this would do is it would allow people 21 and over to smoke marijuana recreationally. All right. I will tell you, I did only put the first part of this into the slide. I did not take the impact statement that was prepared because the slide can only hold so much text before it's unreadable, but also because I chose the text of the amendment. Importantly, one thing that does need to be kept in mind, regardless of a yes or a no vote here, is this doesn't change federal law. In theory, federally, marijuana is illegal, and a vote in favor here would not change that. Okay. So what's the current state of affairs for marijuana? By constitutional amendment, adults over the age of 21 can use marijuana if they have a prescription, if they have a medical marijuana card. Okay. It is not legal for recreational use, can't be possessed if you don't have a card. It's a statutory restriction. The state legislature could modify it if they chose. The state legislature could make marijuana legal if they wanted to. And federally, marijuana is still illegal. Federally, marijuana is still illegal. This amendment does not affect that. Does not affect federal law. I feel like that's important to stress because I don't want people voting for or against something thinking that what they're doing is they're changing the federal law. This is just affecting Florida. However, the federal government has not really enforced any marijuana laws, federal marijuana laws in states that have legalized marijuana. So what's a yes vote do? Adults over the age of 21 can possess up to 3 ounces of marijuana at any given time. Current dispensaries that exist, they would be authorized to sell it for recreational purposes. Right now, they can only sell it for medicinal purposes, and they'd be able to start selling for recreational. There is no scheme, no legislative and regulatory scheme for licensing recreational marijuana. The legislature would have to come up with one that would be dealt with in the next legislative session. That's where the new regulatory scheme would come into play. So this isn't going to kick in on November 5th. This gets a yes vote. The election gets certified shortly after. This isn't kicking in right away. There's going to be some lead time to this. but it would authorize up to 3 ounces, and then the state would have to determine how that would be handled and how that would be policed. A no vote, there is no recreational use. The legislature could put that into place if they chose to, but medical marijuana would still remain legal. This yes or no vote does not affect medical marijuana. It only affects recreational use. Amendment 4, and again, I chose not to include the impact statement, which I'll be honest, I think was fairly one-sided. This is another one of the citizen referenda. This is the second of the two, and this is the abortion amendment. You've heard yes on 3, yes on 4, no on 3, no on 4. Those are the campaigns. Amendment 3 with marijuana. Amendment 4 is limit government interference with abortion. It basically limits the ability to for the state to ban abortion prior to viability, or in the case beyond viability in the case of the patient's health. Okay, so what's the current state of affairs? It's complicated. The U.S. Supreme Court overturned Roe v. Wade, which ended the federal protections for abortion, and then it became a state issue. And different states have come up with different schemes. Florida had passed a 15-week ban that went through the courts, and while that was going through the courts, Florida passed a 6-week ban. The Florida Supreme Court upheld the 15-week ban, saying it didn't violate the Florida right to privacy. It's in the Florida state constitution. And so the 6-week ban came into effect. This is all statutory, though. And what that means is that the Florida legislature can change this at any time if they want. What's a yes vote? A yes vote makes Florida a state that allows abortion up until viability, and viability is a medical term. And it also allows for abortion after viability if it's necessary in the opinion of the healthcare provider. It doesn't prohibit the legislature. So while it prohibits the legislature from passing laws banning abortion, it doesn't prohibit the legislature from creating laws around parental notification. That would still be allowed. A no vote allows abortion bans to stay in effect. In Florida, the current legal scheme would be that it's only available for the first 6 weeks of the pregnancy. And the legislature can change that at any time. They could raise it up to 15 weeks, up to 20 weeks, up to viability, or they could lower it to almost never. So a yes vote would basically take it out of the legislature's hands, and a no vote would keep it as the legislature to do what they want. Okay, Amendment 5. You don't hear a lot about Amendment 5. Amendment 5 is wordy and it's a little dense. It's another one that I think has some significant impact that nobody's really talking about a lot. Amendment 5 is an adjustment to homestead exemptions. This is not the sexiest of the amendments that we're dealing with. And it feels a little unfair to it for it to come right after you talk about abortion, you're talking about medical marijuana, and now we're talking about property taxes. It feels a little unfair, but here we are. We're going to talk about property taxes because this amendment talks about taking property tax exemptions and adjusting them for inflation. So the current state of affairs, Florida, if you're a homeowner, you know, gives a property tax exemption. It's $25,000 for school taxes, and it goes up for non-school taxes. These are not changeable amounts because you may not know this. Numbers come from the Florida Constitution. These numbers were set in the Constitution. These are what the numbers are going to be. Because of that, it's going to take a constitutional amendment to change all of it. And so that's where we are. A yes vote would allow that exemption to be increased based upon inflation. It would increase both the school and non-school exemptions. every year on January 1, well, probably on January 3 or 4, the new exemption would be calculated. This would take in effect, this would go into effect starting next year. So if this gets enough votes as a yes vote, this would kick in starting January 1, 2025. You would see a change, an increase, probably, in your property taxes. You would in your property tax exemption. Sorry, you'll always see an increase in your property tax, but you'll see an increase in your property tax exemption. It doesn't say that it allows for it to decrease, and because of that, I'm assuming it would stay, so because of that, it would stay flat, but it could never decrease. No vote keeps the exemptions where they are. It doesn't allow for future increases. I don't love how I wrote this slide, and now I'm looking at it. I don't love the wording of it because you can increase it, but you would have to do it by constitutional amendment. They'd have to repropose this in 2 years. There's no statutory regime that can increase the limits without the constitutional amendment, though. A yes vote does mean a lower tax base, but it also means savings on property taxes. So there's a trade-off on that. And finally, amendment number 6, which is the last of the constitutional amendments for Florida, repeals the provision of the state constitution, which offers public financing for about 3 offices. Okay, this is another amendment that is basically trying to amend a Florida constitutional amendment from previous elections. Elected cabinet positions and governors. So elected cabinet positions is attorney general, is agriculture. I think CFO is considered an elected cabinet position. There's not a lot of them. And of course, governor and lieutenant governor counts as part of the governor's race because there's not a separate election really there. Has public financing of campaigns. There's certain things you have to do. You have to raise a certain amount of money. You have to abide by certain restrictions in how you use the money. And the state will give essentially matching funds to for donations. This only counts for the campaign. So if you have a PAC that is also running ads on your behalf, that is also spending on your behalf, that's not covered under this. They're not eligible for the match, but they're not covered under the restrictions either. In 2022, the state paid out about, a total of $13 million to candidates for 3 offices: governor, chief financial officer, and attorney general. And more than 2 candidates per office can receive funding because Nikki Fried, for example, in 2022, she received campaign funds, even though she only made it she didn't make it through the primary. She lost in the primary to Charlie Crist. So more than 2 candidates per office can receive these funds. A yes vote eliminates it. It's done. Program gone. That's the easy part, right? A yes vote eliminates it, removes any expenditure caps for these races for people who choose. It doesn't prevent the legislature from choosing to reinstate it as a legislative program, but it would no longer be a constitutional program. And a no vote just keeps it in place. There's no change to the system. Before I jump into the Orange County Charter amendments, let me stop for a minute and see if there are any questions or see if there's anything that people want me to go over again with the constitutional amendments. Throwing a lot of people and I'm doing it quickly, I realized. The good news is that the constitutional amendments are, I think, a little easier to understand. The hardest one, I think, was number 5. The charter amendments get a little dicier in Orange County. I think they're a little the Orange County charter amendments. Kevin asks, what's the medical definition of viability under 4? Actually, I don't know. Let me table that and let me see if Google has an answer for us on that real quick. While I'm looking that up, let me talk a little bit about what happens with the Orange County Charter. Orange County Charter is different from the Constitution in that it only requires 50% plus one vote. Okay, so 50% plus one vote is in and of itself, I think, fairly straightforward. It doesn't have the same requirement that it goes through excuse me, that it goes through that it gets to 60%. So right. So most likely, medical viability would then be something that would have to be defined by the legislature. There is no definition in the amendment. You saw the ballot language as I showed you. There is no definition of medical viability in the amendment, so it would probably be something. It would be up to the courts and the legislature to decide what constitutes viability. Usually, it's the fetus is able to survive outside of the womb on their own, so somewhere between 20 to 24 weeks is the standard, but that's what I got. But it is not defined under Amendment 4. So keep in mind that under Amendment 4, the legislature could define viability, and then the courts would have to decide if there was a challenge to that definition of viability. So going back to the charter amendments, they only require 50% plus one. There is a method for citizens to put amendments into onto the ballot. We're actually going to talk about that in a minute, but none did this year. These are all from either the county commission or the charter review commission, which submitted to the county commissioners who had to approve it. So the first one actually amends the charter initiative petition process. Okay, it would lower the amount needed from 10% of registered voters in each commission district to 5%, and for ordinances from 7% to 3%. There's some other things that would go into it as well. Okay. Currently, as I said, there are certain requirements that a citizen petition needs to meet in order to get onto the ballot. This would make it easier for citizen initiatives to get onto the ballot. It would make it easier for citizen initiatives to amend the charter or to get ordinances in front of the county commission. This affects both of those things. No vote would keep the current standard in place. For this one, we're just going to go over what a yes vote would do. A typo on the slide that I missed. Amendment 2 would amend the county charter to require the Affordable Housing Trust Fund stay in place. So Orange County has an Affordable Housing Trust Fund. It is created by ordinance. It is not created by county charter. By making it a charter trust fund, makes it that the county commission can't just eliminate it, can't just be done with it. All right, it was so the county commissioners enacted the Affordable Housing Trust Fund in 2020. county ordinance could dismantle the trust fund. It was originally, I don't think, meant to be a long-term thing, but it probably is needed to be. A yes vote makes it part of the charter. Once it's part of the charter, it cannot be dismantled just by a legislative vote. It would require essentially a new charter amendment. Charter Amendment 3, write-in candidates. This is one of those that, again, has some effect that I think people may miss the significance of. And this is playing out kind of right now in District 1. So it would amend the charter, and this would only affect charter offices. So the county mayor, county commissioners. Importantly, this does not affect school boards. If Florida Amendment 1 does not pass and school boards remain nonpartisan, they are still not affected by this amendment. If school boards remain nonpartisan, they are not affected by this amendment. Judicial elections are not affected by this amendment. No other races will be affected by this except for the county mayor and county commission, unless things change and they change the county charter to make other positions elected. Write-in candidates don't count towards the number of qualified candidates necessary to trigger an election at the August primary. Okay. Right now, if a write-in candidate qualifies, then the election counts as if there were 3 candidates, even if someone hasn't registered. Where do we see that? We see that in District 1, where a write-in candidate got it qualified, and even though one person won the election by about 2 votes, that is a really tight election. They're still going to end up with a runoff in November because it's being treated as a top 2 as a 3-person election. So somebody didn't get enough votes to move forward. A yes vote would take the write-in candidates out of the ability to act as spoilers. Quite frankly, is what it is. It prevents somebody who hasn't fully qualified and hasn't gone through the full candidate process from acting as a spoiler to force an August and then the November election. Importantly, again, I'm stressing this because it matters. We're talking a lot about a couple of different races. This only affects county mayor, county commission, which would remain nonpartisan, even if the school board amendment passes and they become partisan. Amendment 4, I'm going to spend all of a minute on. This is one of the ones that is there. It would have, this is going to be significant for some things later on. A fiscal sustainability analysis tool. What they're really looking for here is a methodology for development to analyze fiscal sustainability for development in rural areas. This is, in and of itself, there's not a lot here. This is building on some of the development, the amendments affecting development that are going to be later on. So what they would have to do is create a standard adoption to a standard tool. They would have to adopt a They would have to adopt a standard tool for analyzing whether a development is fiscally sustainable. Fiscal impacts right now are provided as necessary, and they're not really, and they're provided by people who say this is how I came up with it. There's not one standard analysis that's done necessarily by the county. This would require a standard be put in place. This would require the county to say this is how we're going to do it. Now, it would require the county to pass an ordinance to say this is how we're doing it, but it would require the county to do it. That the county could then change the tool and the analysis methodologies as they chose to, but they would have to have one in place at all times. This is going to be important later. Number 5. Orange County Charter Amendment establishing charter office of the county attorney. Charter offices mean that the office is established in the charter. They are not just a county employee, they are a charter employee, which means that they can't just be hired and fired by the mayor. Right now, there's a county attorney. He's hired by the mayor, he can be fired by the county mayor. Almost definitely an at-will employee, but a yes vote would change it so that the county commissioners have to approve the county mayor's choice for the chief legal officer. And it would allow the county commissioners to fire the county attorney without the approval of the mayor. And it would allow the mayor to fire the county attorney without the approval of the county commissioners. So anybody can fire the county attorney, but everybody has to agree to hire. What this does is it means that the county mayor doesn't have sole authority to pick their own chief legal officer for the county. It does not, even though it's a county office, make it an electable an office that you get elected to. Number 6. We have 6 districts in Orange County right now. 1, 3, and 5 are up for election this year. 2, 4, and 6 are up for re-election in 2026. This would add 2 more districts. So the entire Orange County would be redistricted. And instead of being in 6 districts, we'd all be split up into 8 districts with 8 county commissioners. There was a realignment in a redistricting in 2022, where each county currently holds between 230, each district currently holds between 230 and 245,000 people. That would be reduced to about 178,000 people per district. It would change the number of board members you need for majority and supermajority votes. Again, which is going to become important soon. I keep saying that, but what you're seeing here with Orange County is each amendment independently makes some sense and has some importance, but they're kind of in some ways building up to a larger full picture with the last 3 that involve development. So starting in 2026, we go from 6 districts to 8. In 2026, there would be elections for districts 2, 4, 6, 7, and 8. District 7 would serve a 2-year term. District 8 would serve a full 4-year term. If somebody moved from District 3 to District 7, they would not be able to they would still have term limits. It would not reset their clock for term limits, as you know, you are allowed 2 terms, and then you have to step off for a term before you can run. Excuse me, before you can run again. So this would not affect term limits. If somebody had a term count, they would do stepping into a new district would keep their term count the same. Okay. Number 7. This would create another commission, a charter commission. Again, because once a commission is created as a charter commission, it doesn't change so much their regulatory authority, because most commissions don't necessarily have any. They can only make recommendations to the county commissioners. But what it does do is it makes it so that the county commissioners can't just disband a commission on their own. They would hold hearings, make proposed expenditures for transportation purposes for the budget, and then review review expenditures that were already made. This already exists. The transportation committee already exists. This is, it's established by ordinance, and this would establish it as a charter committee so that it would be, it would continue. Fundamentally, not much would change with the charter, with making it a charter committee. It would still be, commissioners, on this commission would be appointed by the county commissioners. Usually each district gets one person. And this commission would then be a charter commission. They would make recommendations on expenditures. They would not have authority to make expenditures on their own. Importantly, this is setting up an advisory, essentially an advisory commission. A charter level government advisory commission. It is not setting up a new transportation authority. 8, 9, and 10. We're at the last 3 amendments. Running through this pretty quick today. I'm actually a little concerned about missing things, but 8, 9, and 10. We're going to talk about each one, then we're going to come back and talk about all 3, because what they are doing and what I've talked about before is they are setting up for a larger kind of full picture. 8 creates county protected lands. These are county owned, operated, or maintained public lands, which means they are not necessarily county owned. It can be county maintained land. Importantly, it is county owned, operated, or maintained land, which means if the land is owned by a CDD, it may not be covered under this. Public parks, recreation, environmentally sensitive lands, if they're owned or they're acquired by the county. Any kind, so that term doesn't exist. But it would create it in the charter. And by establishing what these protected lands are, any disposition taking them out of protected status, which means either to sell them to a developer or allow development on them, or just take them out of protected status so that they're used differently, would require not just a majority vote, majority plus 1. That sounds, I want to make sure that that's clear what that means. A majority vote, there's right now 7 members of the board, 6 commissioners and the mayor. So majority vote is 4. Majority plus 1 is 5. So you need 5 out of 7 yeses. If this if the charter amendment making us an 8 district county passes, you would need 5 of 9 is majority, 6 of 9 would be required for this. In order to move lands out of protected status, lands are designated as protected, that wouldn't necessarily require an ordinance to get them in there. You go back for a minute. Any public parks, any recreation areas, any environmentally sensitive lands, by their nature, become county protected lands. They become county protected by, snap of the fingers, wave of the wand, by force of charter law. It happens pretty much instantaneously. Anything that becomes a public park or a recreational area becomes a county protected land. And once it's in, it's harder to get it out. So that'll make certain areas a little harder for development. Number 9 does something really similar. Establishes a rural area, which is going to be outside of the county's urban service area, but also outside of the municipal joint planning areas. So joint planning areas with some of the cities in Orange County, it's going to get out of some of the the expansion areas like Boggy Creek, Horizon West, where they're already planning to do expansion. And where the comprehensive plan already has them kind of marked off as rural. This is an amendment affecting that development. This is all an amendment at limiting development in rural areas where there's already not approved development. Right now, there's not really any special protection for rural areas. And a change to it only requires a simple majority vote. A yes vote would establish this rural boundary. Again, outside of areas where there's already a comprehensive plan in place. And any changes to the density to increase the density of these rural areas would require, again, that majority plus one vote. Then the last one, which deals with voluntary municipal annexation. And that's a mouthful, but really what it's talking about is taking, is cities taking over county land usually at developer request to make those developments part of a city. Mostly that's Orlando, but not exclusively. Mostly that's Orlando, but not exclusively. So that's going in and the city's taking over the space and making it part of their own. The big reason developers sometimes like that is because the city commission might be easier to work with in development. Takes it out of the county's comprehensive plan, puts it into the cities. Right now, the county only has veto power over the annexation of certain districts. And for for a municipality to annex those portions of the county commissioners have to approve by simple majority. If it's outside of a preservation district, there's no veto power that the county has. The city can just annex it. Here, voluntary annexation outside of a joint development plan with that municipality is subject to veto by the county commissioners. So, for example, Lake Nona, when they're building apartments in the county on the county side of Narcoossee, and then they try to annex them into the city side, this would allow the county to say, no, we're not going to allow that annexation. It's less for that one-off, but what this is really trying to do is keep is prevent large-scale annexations of rural of underdeveloped areas, of areas that are a little more rural in Orange County. Gives the county veto power of the annexation, and it makes the requirements for annexation more difficult. It's going to increase the complications, it's going to increase the steps required. This is all building to the same thing. Okay. I told you I was going to bring this all together at the end. Here we go. If you look at, all these amendments, 8, 9, and 10, along with some of the others, what they are doing is they are looking at trying to limit construction and limit new development in Orange County. Not stop it necessarily, but limit it and make it so that it's a little harder to do, limit it so that it's a little more, it requires more public hearings, it requires the builders to give more notice, requires the builders to make sure that the people who would be affected by that annexation are heard. The advertising requirements would be different. The letters that would have to be sent out would increase and would change. The cost would increase. And that is the goal of these amendments put together. So with that in mind, I'm not going to tell you vote yes or no, but I am going to tell you if what you want is to limit development, then you probably want to vote yes for several of these because they're all kind of working together. If you want to allow more development, you probably want to vote no for most of these because, again, in and of each one on their own does a little bit of the larger part of it. So it really becomes a question of, for a voter, if you want to limit development or you want to allow more development in Orange County, that's then how you would start playing out which one of how you would vote on these amendments. All right. One thing we didn't talk about, and not really what I'm gonna cover here. There is also on the ballot a half-penny sales tax. That goes, not sorry, not half-penny sales tax, half-penny, mill for, Orange County schools. Um, this is, an approval. It's been in place for for a while. And that's money that the school district uses for, various things. The ballot's about 4 pages front and back this year. I'm not gonna tell you how to vote, but I'm gonna suggest you vote by mail. Or early voting, because election day is going to be long lines, and I, for one, don't like waiting on lines. So I'm a big proponent of voting by mail, especially this year. If you are not registered to vote, you have 7-ish days. You have to have your registration in by October 7th. If you are going to vote by mail, you need to put that application in by October 27th. I would recommend getting it in earlier. If you are voting by mail, you can drop your ballot off at any early voting site. But if you do not drop it off, it must be in the hands of the supervisor of elections by 7 p.m. on election day, which means you cannot drop it off at a ballot at a voting site on election day. You have to take it to the supervisor of elections office downtown, which sounds to me almost as bad as voting on election day and waiting at those lines. Polls close at 7 p.m. If you are online at 7 p.m., you are still allowed to vote as long as you stay in line. If you get out of line, you lose your place. If you show up right before early voting closes, they do have to let you vote, but they may judge you a little bit for showing up right before early voting closed when they probably didn't have a long line before that. I'll open it up to questions. If you liked it, I hope you did. If you didn't, my name is Matt Rosenthal. If you loved it, my name is Justin Meyer. I will be doing at least one more of these towards the end of October. I will try to get this one online probably a little later this week or early next week. And if there are groups that want us to do this, we're happy to go out and provide this more often.